Hello and welcome to our presentation today on extended school year services. My name is Mike Connolly, and I am the current CEO and managing partner for McAndrews, Mehalick, Connolly, Hulse and Ryan. And I'm here today with Rachel Rosenberg, and I'll let Rachel introduce herself.
Hello, my name is Rachel. I'm an attorney in the special education group here at McAndrews Law.
All right, so today, as I said, we're going to discuss extended school year services, what families need to know. We're going to talk a little bit about both eligibility, the program itself for extended school year services, and what you can do if you have disagreements about that program. So with that, we'll go ahead and get started. So we're going to first talk about what is extended school year services or ESY services and who gets them. So these are essentially special education services and related services provided to students with disabilities beyond the regular school year that they would receive, and they're designed to for a variety of different factors that you may be eligible for these services that we'll talk about a little bit later, but they're really designed to be providing you not necessarily the full program that they receive during the school year, but certain areas that may be impacted by that summer break that they want to address. So they extended school year services. Generally, they're entitled to them if they're needed for a free appropriate education or a FAPE. The qualifications there are in Pennsylvania, 7 additional factors that have to be discussed and considered in making eligibility determinations, which Rachel will start talking about in a little bit. But generally, if it's necessary for FAPE, a student would be entitled to extended school year services. Now, a decision on whether a student is eligible and what that program is going to look like needs to be made in a timely basis, but exactly when depends on the nature and severity of the student's disability. So students with severe disabilities like autism, intellectual disabilities, significant emotional disabilities, those types of disabilities, a decision regarding eligibility for extended school year must be made by February 28th. Preceding that summer, and a NORUP regarding eligibility and the program that the student is going to receive, the specific details of that ESY program, has to be issued by March 31st, so that it gives enough time for any disputes or resolutions to occur well in advance of the actual extended school year program. For students that do not fit within the severe disability category, a decision still has to be made in a timely basis to give the parents an opportunity to disagree. Given the nature of due process hearings related to extended school year services, in most cases, you're probably talking about, depending on when the ESY program starts, you're probably talking about really certainly in April or May at the latest determination regarding eligibility and programming for students' ESY program, even if they are not in that severe category.
As Mike just mentioned, there's a statutory code in Pennsylvania that lays out what districts must consider when determining whether a student will be eligible to receive ESY. So the IEP team must make consideration. There are 7 different factors that are laid out in the statute to determine whether a student is eligible for ESY. And all students with disabilities should be considered for ESY services during IEP meetings. So while Mike mentioned that there is a different timeline for students with severe disabilities, all students who have an IEP should be considered for ESY. It doesn't matter what disability or what eligibility a student may have. The severity of a disability can be considered in that in those factors. It's one of the seven, which Mike will discuss later, but all students, regardless of disability, can be eligible. So the first factor that an IEP team has to consider when determining whether a student is eligible for an IEP is the likelihood for regression. So that means whether a student reverts to a lower level of functioning as evidenced by a measurable decrease in skills or behaviors which occur as a result of an interruption in educational programming. So while all students may show some regression over, for instance, a summer break, if a student is more likely to experience significant regression, that would be a sign or lean toward that student being eligible for ESY. And that could be regression in academic abilities, behavioral, or functional, anything that is related to that student's FAPE. The second factor that an IEP team considers that kind of goes hand in hand with regression is recoupment. So that means a student's whether the student has the capacity to recover the skills or behavior patterns in which regression occurred to a level demonstrated prior to the interruption of educational programming. So that means if a student does regress over, for instance, summer break, which many students, regardless of disability, may regress to a certain extent over a break, does that student have the ability to recoup those skills in a reasonable amount of time? And if the recruitment period takes longer than a reasonable amount of time, and for instance, it could typically take a student 6 to 8 weeks after the start of the school year to recoup skills from the prior year. If a student takes longer and needs more time to recoup, that's a sign that they could be eligible for ESY. The third factor that a team considers when determining whether a student's eligible for ESY is whether the student's difficulties with regression and recoupment that we just discussed make it unlikely that the student will maintain the skills and behaviors relevant to IEP goals and objectives. So if a student had mastered an IEP goal, depending on that student's disability, would the skills that they had related to that specific IEP goal be specifically prone to regression or trouble recouping those skills if a student did not benefit from ESY? Similarly, the team also considers the extent to which the student has mastered and consolidated important skills or behaviors at the point when educational programming would be interrupted, meaning is what a student had been working on prior to a break specifically likely to, would a break in those skills, not receiving ESY, make it specifically hard for a student to progress following returning to educational program? Will a break threaten the progress that a student is making? If a break would threaten that progress, then that student may be eligible for ESY services.
And just one thing to point out, the regression and recoupment as it relates to IEP goals is what you will see 95% of the time districts focus on in ESY discussions in regard to determining eligibility, and a lot of times really gloss over or sometimes even completely ignore the other factors. So it's really important to be aware of these factors so that when you're in those meetings talking about your child's eligibility, you can have discussions and say, well, what about some of these other factors that may be particularly relevant to your child, depending on his or her needs. The next factor is whether or not a particular skill or behavior that they're working on is particularly related to or crucial or critical for achieving self-sufficiency and independence, which is one of the primary goals of the IDEA, and is to allow students to become as self-sufficient and independent as possible. So if it is a real critical skill towards that in and of itself can be a reason for a student to be determined eligible for special education. And then the sixth factor is the extent to which multiple interruptions in educational programming is going to result in a withdrawal from the learning process. So that's kind of taking, there are breaks throughout the school year, so they are having successive interruptions in their programming, whether it's Thanksgiving, spring break, the winter holiday break, or other in-service days, long weekends. There's breaks throughout the school year, and when you look at all those breaks, and then you've got now a longer summer break, is that going to result in the student kind of withdrawing from that from the education and making it much more difficult for the student to re-engage in education when the fall comes around the following year? And if the answer to that is yes, then that in and of itself again is a basis for eligibility. And then the severe disability is the seventh and final factor, which is really the same category that you're talking about those students who would be required to have a determination of eligibility by the end of February, and in NORP outlining the program by the end of March. So we're talking about students with autism or pervasive developmental disorders, serious emotional disturbance, severe intellectual disability, degenerative impairments with some sort of mental or cognitive involvement, or severe multiple disabilities. So all of those students, that the severity of their disability alone could be enough to qualify them for eligibility, regardless of the other six factors that we talked about. Again, the decision about IEP eligibility doesn't have to be made until the timelines that we talked about, but a discussion of ESY should be occurring at IEP, meaning certainly at least the annual IEP review, even if that is in the fall or in the middle of the school year and not at the time where a decision is going to be made. There still needs to be some sort of discussion about it, with the idea that a final determination may be made later, but it should be discussed at those IEP meetings. So in looking at all these factors and kind of deciding what are we looking at, how do we make that decision, there's a variety of sources of information that the IEP team should be looking at in making these determinations, and they should be collecting data to address and discuss the different factors and be able to then make a determination on that. So we're looking at things like their actual progress on their goals over the course of the years, and even going back and looking at consecutive IEPs, what kind of progress on goals are they making? Looking about data on regression and recoupment that they have taken over other breaks in the school year, as well as maybe between last summer and last fall, and that kind of data. Private outside reports, medical diagnoses, observations from teachers, and observations from you as the parent. All of those things are relevant, including any other testing results that the district may have. So all that kind of information is relevant and should be part of the discussion in making a determination on eligibility for extended school year services.
So after an IEP team goes through all of these factors and makes a decision regarding ESY, it needs to issue a NORP and PWN, just like it would when making any decision related to a student's IEP. So that's a notice of recommended educational placement and a prior written notice. So following any determination related to ESY, and that could include not only the decision whether to provide any ESY services. It also would need to be issued following a decision to remove ESY services from an IEP. They would need to issue a NURP following a decision to deny parent requested ESY services. So if a parent requested to the IEP team that ESY be added to an IEP. And after going through these factors, or a team decides not to provide services and deny that request, they would need to issue a NURP and PWN, making that clear. They would also need to issue a NURP after changing or denying to change an existing ESY program. So that means that not only do they need to issue a NURP if they just choose to provide ESY generally or not to provide it, they also need to issue one if they make any changes to that actual program, what services are being provided for how many hours, et cetera. And ESY, so as we've discussed, ESY is provided if it's needed for a child's or for a student's FAPE. It's given to provide that benefit for a student who needs it for FAPE. It's not for daycare or respite services. It's not for summer recreational programs or for camp. It's only to ensure the provision of FAPE. So ESY programming can look different depending on the student's needs. ESY should be individualized for a student, just like an IEP should be. There's no one picture of what ESY looks like for students. That said, many school districts have a standard structure of what their ESY program looks like. It's often about 5 weeks, not the entire summer. It's often 3 to 5 days per week, a few hours. It could range from a few hours a day to a full academic school day. And a family might disagree with a district about what ESY is provided because, again, it should be specific to the needs of a student and individualized to that student, just like a student's general IEP is. And families are entitled to timely resolution process in order for their child to receive appropriate services. So as Mike has already described, that timeline is really specific for students with severe disabilities, but for all families, regardless of the disability, decisions about ESY should be made on a timely basis to provide time for family to disagree about what services are being provided.
And again, just keep in mind, this is the kind of standard district programs that you see in most districts over the summer. Not, and that for many students that may be sufficient, but again, it is always individual. So whatever your child needs, and it could certainly be longer and more intensive than that if that's what's necessitated.
So like we just mentioned, an ESY program has to be individualized to meet the student's needs. So the services that are provided through ESY depend on what services that student needs to maintain a FAPE. So that could mean a variety of different things. It could mean the same services received during the regular school year. It could mean some services received during the regular school year, or it could mean one service received during the regular school year. So it all goes into how many services that particular student needs for purposes of ESY. So for instance, if when making the eligibility or making the determination that a student requires ESY and looking at the data, the team looks at the regression and the recoupment and finds that a student regressed on their reading abilities, but they didn't regress on their math abilities. And this student receives IEP services related to reading and math over ESY based on that likelihood for regression and recoupment. They may only need to receive reading services and not math services during ESY. It depends on what that student needs in ESY to avoid regressing the following school year. For a location of ESY, where is it going to take place? That varies as well, and it will be determined by the IEP team. So an IEP, part of the IEP determines that a student always needs to be provided services in the least restrictive environment, and that applies to ESY too. However, the district is not required to gather students without disabilities to create a less restrictive environment during ESY programming. So if during the regular school year, a student's least restrictive environment requires that student to be educated in a regular education setting with other students in the general education setting for a certain amount of time of the day, either 100% of the day or a certain percentage of the day, that would not be required in the provision of ESY services. And ESY can take place in a variety of places. It's often at school, but it can also be at, for instance, a place of employment or a non-academic setting if it's deemed appropriate. Again, this all goes back to the fact that ESY, just like the provision of services during the regular year, is individualized and depends on the needs of a particular student.
Right. So, like, say, for example, you have a student who is the older student and they're transitioning and they're really focused in on employment skill development, whether it be soft skills or hard skills. And during the year, they have part of their program is actual, work study or some sort of employment position. That might continue as part of their ESY program, and that job coaching or whatever type of support that they received during the regular school year in that setting might continue. Or if you have a student who really has social skills needs that need to be developed, maybe a non-academic setting, this is kind of the situation where certain types of camps may be appropriate. As a general rule, it can't be for the purposes of summer camp, but a non-academic, more social type atmosphere, if that's what a student needs in order to work on the goals that are going to be worked on for ESY, then that kind of replacement could be provided. So what about pendency when it comes to extended school year services? And first, in case anybody's watching this and that is not sure what we're talking about when we say pendency, we are talking about what program and or placement does a district have to implement while some sort of disagreement is going on over a program or placement that's being proposed by the district. And in order for pendency to be implicated, a parent must disagree with the NORP and must request either due process or mediation. Any other requests, like an informal meeting or just saying no and not requesting anything, does not invoke pendency in the new program, including any kind of new ESY program, would be the now pended placement in any future dispute after the NORP is returned. So you do have to initiate one of those two things, and you have to do it within a reasonable time, which has been interpreted in Pennsylvania as within 10 days, 10 calendar days of receiving that NORP. So first question is, does pendency exist in the context of extended school year? And there is argument about this, whether pendency actually does apply to extended school year services or not. I do think it applies, and I think it applies as it relates to eligibility programming, both of them. However, it is, as we'll talk about a little bit later, any sort of dispute on ESY through mediation or due process is going to be on a much more condensed time frame than a typical due process scenario, because the purpose is to get it resolved before the program is up or the ESY program starts, so that you have resolution from the due process hearing. So I don't, pendency, oftentimes the issue gets resolved before the program actually occurs, so the pendency doesn't always come up. But if it is an issue, I do think it exists, but be prepared that you will probably get a fight from the school district, possibly on whether or not pendency exists for extended school year services. So a couple of other things. Some students are not attending their regular school or school within their district, and they have been placed by their school district in an approved private school. They still must be considered for extended school year services, just as though they were in the district. And the same rules for why they would be eligible, what the program should look like, timing for making a decision, all of that stuff must be considered. And the school district or local educational agency, LEA, has to provide those services if the student is determined eligible for ESY. That service could happen at the APS, or it could, in theory, happen back at the school district or some other location, again, based on the student's individual needs, the same as we've already discussed today. Some students are placed in APSs by the parent, even either sometimes at their own expense, sometimes through an agreement with the school district, where the school district is funding the placement, but they are not responsible for FAPE during the period of time that they're funding the placement. So if a student is placed either way at an APS by the parent, either the district's funding through an agreement or the parent is paying for it on their own, there is not necessarily a entitlement to extended school year services from the school district. Certainly, the APS may say that the student requires ESY services, and you can access those at your expense in that situation. Additionally, if there is a settlement agreement, the settlement agreement will likely control to what extent the district is responsible for any sort of tuition amounts above and beyond the standard school year tuition for the school to include, and whether it includes extended school year services or not. But otherwise, at an APS, a student would still be entitled to ESY services. Same rule as parent placement at an APS also applies to situations where parents have placed their student in a completely private school, not necessarily an approved private school, but a licensed private school of some sort on their own. Again, there would not be the entitlement to ESY services per se from the districts. Disagreement. So what if you disagree with either eligibility or the program that the district is putting out there for extended school year services? Recommend that you first attempt to resolve your disagreements if you can during the IEP meeting. Try and have that discussion with the districts. ESY is, when from time of determination, particularly if your child does not fall into the severe disabilities group, but even if they do, time of determination and offer of NORP to time of program is not a long period of time. So there's a lot to occur in a very short period of time to try and get that resolved. And it's just, if you can come to that agreement in an IEP meeting, it makes things easier, it makes things more smoother, and it's always worth a try if you're in that IEP meeting and there's a disagreement, to try and have that conversation about the disagreement and see if it can be worked out. If not, you do have multiple options here. You can certainly always request either an informal meeting or another IEP meeting to discuss it further. If you want, and it's not resolved at that initial IEP meeting, again, under that scenario, you are not invoking any possibility of pendency. Particularly if IEP meetings occur, they've issued a NORP on ESY, and you ask for another meeting, which you can. You don't get pendency at that point. The new program or determination that they've made goes into effect. You can also ask for mediation that we talked about, that would invoke, at least in my opinion, pendency. And then you can also ask for a due process hearing, which again would invoke pendency. Due process hearings for ESY are expedited. So that means they occur on a much quicker time frame. So there are generally the entire thing must occur within a 45 days. So from filing to decision in the due process hearing is 45 days. I believe the resolution period is reduced from 30 to 10 days, and the due process hearing can be scheduled as of day 20. Or day 21 as opposed to day 31. And I believe the resolution meeting is required to occur within 7 days of filing, and the disclosures for the due process hearing are 2 days prior to. So everything is reduced and much quicker in order to try and get that determination out by the time that ESY occurs. And if it's a later due process hearing request, like it's not a March or early April request because of a determination made in February or March, a lot of hearing officers, at least in my experience, will note the date that they're getting this request for ESY and assume ESY is going to start sometime in late June, early July, and they will schedule a hearing as quickly as possible so that they can get a decision out before that decision, before that ESY program starts. So it does happen on a much quicker basis. They're going to pick a date, and while they may move it a couple of days here or there, if that helps somebody's calendar, they are not going to grant generally continuances in ESY expedited due process hearings. So that is ESY in a nutshell. If you have more specific, if you have specific questions about your child's specific situation, you should always feel free to reach out to us at our office. So we hope you found this presentation helpful today, and we hope you have a good summer. Thanks.
Thank you.